From Acquisition to Exit is powered by Buy, Build, Sell, where business empires begin and profitable exits are made.
Welcome to another episode of From Acquisition to Exit. Today we're visiting with Scott Williams of smallbusinesslaw.org and diving into how to protect your deal, avoid landmines, and set yourself up for a smooth exit when you're ready to retire. Scott's worked with hundreds of business owners through the messy middle of deals, from first-time buyers to seasoned sellers. He's not just your typical business attorney. He's an educator, a trusted guide, and someone who's seen how the right legal foundation can add serious value when selling your business. Scott is also a former member of the board of directors of the California Association of Business Brokers, where he teaches their legal compliance courses and frequently speaks at their conferences. Please welcome Scott to the show. Hi, Scott.
Ray, thanks for having me.
It's really wonderful. One of the things that I really enjoyed right out of the gate when I looked at your website and the history that you have, what's really wonderful for this audience is you really cover a broad spectrum of business related law. You do deals, you help people through estate planning, and you help everybody, with even litigation and, even tenant leases and that kind of thing. I was really impressed with the scope and breadth. It just would be great to hear an opening of how your practice has gone over the years and just like what's led you to do this. What drove your passion for this work?
Sure. I grew up as an entrepreneur running a pool service and spa repair business when I was in college. I eventually sold that when I got commissioned as a lieutenant in the Air Force. So I had an entrepreneurial background and spirit from day one. When I eventually went to law school and launched my practice, I said, there's so many firms out there that are good at what they do in the areas of consumer law, bankruptcy, personal injury, family law. That's all great. Most of the business law firms were all focusing on big corporations, big fish, large organizations. I said, where's the law firm for the little guy, the small business that is the entrepreneurial engine that drives America? And I just didn't see it. So we launched the tagline, the small business law firm, and that eventually became the name of our firm. And today we are the small business law firm.
So today we're going to cover a few questions for our audience that will help them through the entire life cycle. We will look at the point when they're starting to buy companies or to initially start them, and then what we call the messy middle of what it's like to build a company and thrive through that cycle. And then we'll take a look at both ends, folks. If you're buying a company, we're going to look at the end with the end in mind. So you do the things that you should do on the front end that sets you up for success later on when you sell the company. And then we'll talk about what it's like to sell the company. Hopefully we're going to cover a lot of ground in a short time. So, right. Of course, but let's get started, Scott. So, actually the first thing, just because I know from personal experience how important it is to have a close relationship with an attorney for the life of your business. And I do mean relationship, and because they are there for you through thick and thin, and they're keeping you out of trouble and helping you to thrive. In your experience with working with business owners, what should they look for in a lawyer, and what makes a good match for a business owner?
A business owner needs a lawyer that can handle the bulk of their legal needs. Somebody who is nimble, responsive, and somebody who gets to know their business, kind of an inside, outside general counsel. And I don't mean to say that big firms can't provide that level of service. They can, but you get one lawyer for contracts, you get one for trademarks, another for employment law, and heaven forbid, they don't talk to each other. Nobody knows your business. Or if they do talk to each other, they want to bill you 3 times the hourly rate for 3 lawyers talking to each other.
Right.
You really should, as a small business owner, have a firm that focuses on a small business, and that's their core niche. There's a lot of other good law firms out there that I collaborate with, that I'm proud to work with, and sometimes I have a conflict of interest, and I'll refer to my friends that are good at what they do as well. But they need a small business owner that understands that small businesses, like any startup or new business, they've got financial limitations. You want to be effective in legal services, but you also have to be efficient. And I see sometimes a classic example of you're buying and selling a small business, and you get the purchase agreement. And you can do that in 10 pages effectively for most business transactions, maybe with some schedules and some addendums. But when I see these 80, 90-page purchase agreements from these private equity firms, lawyers, I'm saying, what are you doing? Why are you trying to kill this deal? You're not accomplishing anything. So there's a balance between being effective and efficient, and you can't ignore efficiency.
Yeah, I really appreciate that. Like you, I've seen purchase agreements are just they're trying to do warranties and reps for everything under the sun and into the next life. And there's a real balance to getting a deal done and having reasonable protections built in, and really trying to just overcomplicate things. So I really appreciate that balance.
Yeah,
And also managing the client's budget, ultimately, you're always balancing budget versus risks. That's really wonderful.
we try to treat
Actually,
the client's money as if it was my own.
absolutely. Absolutely. That leads us to the kind of, let's talk about let's say we're a first time buyer and we're about to buy our first company. What do they need to keep in mind? What legal protections should they be thinking about? What documents should they keep in mind as they're about to embark on issuing a LOI or a letter of intent? And maybe just for the audience, for some of those who are new to LOIs, maybe just give a quick, blurb on that. But then let's dive into what do they need to be thinking about at a high level?
Sure. Once you have a preliminary discussion with a seller about buying a business, you're more likely than not working through a business broker, somebody who has a business listed for sale and they've already signed the non-disclosure agreement, or it may be one that's not involving a broker and you're dealing directly with the seller. The process normally starts with a letter of intent. And the common question I get asked is a letter of intent binding or is it not binding? And the answer is it's both. It's non-binding as to the eventual purchase of the business, but there need to be some binding provisions in any good letter of intent, such as confidentiality. If you're a buyer, you want an exclusivity period where when you start spending a bunch of money on financial and legal due diligence, you don't want this seller shopping around the business to the next highest bidder and you're wasting all this money for no reason. So it is reasonable for a buyer to ask for a 30 or a 45-day exclusivity period. And in the same time, the seller has a right to say, great, we'll cooperate with due diligence, but there's some contacts we don't want you making, such as don't talk to our employees and spook them that we're selling the company. Don't talk to our customers and do the same. There has to be a balance between the buyer's right to do due diligence and the seller's desire to protect the integrity and the confidentiality of the process until you get to the point where closing is imminent. Then you start disclosing a bit more information.
Yeah, that's wonderful. And that leads me to the next question, which is, in either in formation, building the LOI out or just in the process of buying the company, what kind of red flags should they be watching for? What kind of things should they be careful of and make sure that they have, proper protections along the way?
Sure. Well, the due diligence process before you actually sign a binding purchase agreement, or sometimes you'll do a purchase agreement that has a due diligence provision. You have to separate due diligence into three categories: financial, legal, and then common sense. The common sense I can't help people with. They need to walk in the business, walk around, observe employees working, see what's going on and say, does this look like an operation that's reasonably well run? Or am I going to have to make wholesale changes coming in the front door? And sometimes if you're a competitor buying a competitor, you're just buying a customer list and you're not keeping the operation at all. That's fine. But you just have to make sure that what you're buying is a turnkey operation. And if you really do need to make significant changes on day one, then you better hope you're getting a heck of a deal on this business and that you're going to increase revenue, because more often than not, the seller sells the business, the buyer comes in and doesn't do as well financially as the seller was doing. And so expectations need to be realistic.
Yeah.
From a legal perspective, certainly there's a legal due diligence checklist that we share with our buyer clients that have them looking over licensing, premises lease, zoning, employment practices. And there's a lot of questions that need to be asked to make sure that the business you're buying is proper. A big thing in California and now in many states is classification of workers. In most states, a lot of sellers and business owners have employees improperly classified as contractors. And in an asset sale, maybe the buyer doesn't have any past liability. But when you tell these workers on day one after buying the business, oh, by the way, you're no longer a contractor, now you have to be an employee, the worker says, I don't want to do this, I quit. Well, if you're going to lose all these workers while you're buying a business, one of the things you look for is a smooth, seamless transition, continuity. You don't want to be losing a bunch of people on day one. And I see a lot of sellers today either misclassify workers as contractors or they misclassify employees as exempt and salaried when they really should be non-exempt and subject to overtime laws.
hmm Yeah, you bring up a really a point about employee classification. If there's another piece that's really important. It's back to the LOI part because a lot of folks think that they're putting in LOI, they're not fully committed, but what they need to realize is that they're starting to spend money at that point. They're starting to spend money on attorneys. They're spending to write the LOI. They're spending money maybe on accountants to help with due diligence and that sort of thing. So it's really important as early as possible to identify, is this going to be the right business or not for me? And, what would be you know, some of those early red flags that we should say, whoa, let's just not even go in on this deal. Like, I want to help build some muscle memory and some training for buyers to think critically before they start bringing in all of the folks and advisors. What are some of the things that they could do on their own right at the front of the deal that would say, okay, wait a minute, this one's not even worth going after? Any major red flags that you would think of from a legal standpoint?
Yeah, I mean, I'd look at things like client concentration. If you've got a business that has one or two or three clients that make up the bulk of its income, how stable are those relationships? Are those relationships really with the business, or are they with the business owner who's not going to be there anymore? That's a red flag. Sudden growth in revenue where all of a sudden the business is kicking butt, taking names, but it wasn't last year or the year before. Is that spike going to be a one-time occurrence, or is it going to be a trend that you can rely upon? Those are red flags that as a buyer I'd look for. I'm looking for stability. Slow growth is good. Valleys and hills, and that makes me nervous.
Yeah. Well, I like back to that concentration piece. We typically we counsel with clients that if they see more than a 20% concentration of any client, we really need to zoom in on due diligence on that client. And from a legal standpoint, what contractual obligations are in place? Are there structured pricing deals that may or may not be profitable in the future? And are there terms that are, really onerous to the company? Or on the flip side, is it just that the client can quit tomorrow, right? And, there's no security in terms of the concentration of those, few large clients.
Yeah. The risk of the business succeeding or failing transfers to the buyer at closing. And assuming the representations and warranties of the seller are accurate, it's on them to make it happen. If they don't have the Midas touch, bad things happen.
Yeah, so we talk about reps and warranties, but I think to a lot of new buyers, that's kind of jargon. Why don't we just kind of break it down a little bit? What are reps and warranties? And maybe at a high level, what are some really high level reps and warranties you want to make sure that you have in your deal, and why?
Sure. Every good purchase agreement is going to have a representation and warranty by the seller that certain things are true. The most common one that everyone agrees on is that if it's an asset sale, that all of the assets being transferred are being transferred free and clear with good marketable title, no encumbrances other than those encumbrances that maybe the buyer already knows about. Sometimes these SBA loans are out there and they have to be, SBA permission has to be gotten to transfer the sale of the business, but the loan stays in place. But for the most part, you don't want to buy somebody else's debt. You want to buy just the assets. So you want to make sure that the seller is representing and warranting that all business activity is properly licensed, that all licenses are current, no licenses are missing, is the premises properly zoned. These are important things. There's no guarantee that a customer is going to stay with a buyer after closing, but you do want to have a rep and warranty that you've not been notified by any key customers that they're going to stop using you, especially if you've got a large concentration. Employees are properly classified, they're properly paid, taxes are current. As a general rule, income taxes aren't the responsibility of a buyer, but payroll taxes in most states very much are. If a seller is delinquent in payroll taxes, those taxing authorities can come after the buyer for up to the amount of the purchase price, and you've got to make certain that you're running all the right checks. And in some states, escrow obtains what's called a tax clearance certificate from the taxing authorities, making sure that the buyer's not going to have these liabilities.
Yeah, the employee part sparks a recent story that I just learned on. I'd love to hear your comment on it. But we had a deal going where the seller was, as the purchase agreement was just about to be signed, and that day, the seller received an EEOC, equal employment lawsuit, or not lawsuit, but complaint from the EEOC. Of course, that became an immediate disclosure. And the thing that we think that we learned, and I would love to hear your perspective on this, is that an EEOC may transfer past and may be able to break through to the other side of the purchase and may stick with the company. Certainly, this is early days, but I'd sure love to hear your perspective on that, or if you've encountered that kind of thing before.
Those type of claims normally don't follow the business assets when they're sold. If it's a stock purchase, then the employer, the corporation, maintains all of its liabilities in perpetuity, and sure, now the buyer's got to deal with that. But in an asset purchase, wage and hour claims, workers' compensation claims, discrimination claims don't normally go to a buyer unless there's a straddle where some of the discrimination is alleged to have taken place after closing.
Yeah, absolutely. It's just interesting. To me, it underlines the importance of having a good attorney like you in place throughout the life cycle of the business, because there are a lot of specialized things that you've never seen before as a business owner that come up like this, and having good counsel through that is so important. Mm-hmm. Let's look at, and as we're having this podcast this week, SBA, the Small Business Administration, is changing again its rules for engagement. It'll be interesting to see what your perspective is on that. But, in the current environment, it's pretty typical to see seller notes and to see earnouts built into the deal. From a legal perspective, from the buyer's angle, what do they need to keep in mind from a legal standpoint? What kind of provisions or thoughts should they be thinking about when there's a seller note involved? And, anything that, it's all fresh still with the SBA, but if you have any early thoughts on that, would be good to share it.
Yeah, I mean, the most smaller transactions under $2 million are financed heavily by the SBA. They're technically funded by a local bank, but they're underwritten by the SBA. And that process right now is going to get bogged down. There's been massive layoffs in government, and there's not enough people to do all the work. It hasn't shut down completely, but it's going to become a lot more cumbersome. So if I'm a buyer buying a business, obviously, if I can finance it, great. But the SBA is going to have its own underwriting criteria, and maybe they won't finance as much of the purchase price as I would like, because the financials of the business just don't support that high of a purchase price. Now you're looking at either lowering the purchase price or getting a lot of seller financing. As a buyer, I love seller financing because I've got a pool of money that I haven't paid the seller yet, that if there is a breach of those seller reps and warranties, normally you can offset those liabilities against the note. But some sellers are dead set against having a seller note. The ones that do tend to devalue their business unless they're selling out to private equity firms that are typically not looking to pay those same multipliers that a smaller buyer might pay.
Yeah, absolutely. Well, and this leads me to a different question, which is, and this we should cover this at both ends of the spectrum, both the buyer and the seller side, which is, what do you wish that buyers of businesses thought more about on the front end in terms of having the end in mind, so that when they get to the other end, your job is a little easier and their exit's a little smoother?
My biggest complaint is that buyers and really sellers, they wait too late to hire a lawyer. I get a phone call saying, hey, we just signed an LOI. Okay, where was your lawyer to review what's missing in your LOI, or maybe what shouldn't be in there? Sometimes I even get we just signed a purchase agreement, but the purchase agreement has a 15-day attorney review period. Well, okay, so legally I can go back and make changes, but mentally the other side's already married to this purchase agreement, and it's tough to get those things approved. So look, the time to get a lawyer involved is early, and the time to get your accounting and financial analysis team is early, not 2 days before closing. Am I paying too much?
Yeah, that blows my mind, actually. I didn't realize that so many people go it alone, if you will, before, and then come and drop it in your backyard to deal with. Yeah, so just to underline that, audience, absolutely, before you start doing deals or even starting your company, get a really good attorney like Scott and work with them on the front end. Make sure you have good chemistry with them. Figure out what you need to get going. That's without a doubt, and still so surprising, Scott, that happens. All right, so let's switch to kind of the messy middle. Sure. A lot of people don't, it's exciting to buy a company. It's also stressful. And then what I find with the people that I work with is, especially the ones who've never owned a company before, they buy the company and they're like, oh my God, now what? I don't where am I supposed to start? What am I supposed to do? What do I even need to be thinking about? Just from, let's just say that we've worked together. I just bought a company. You're my attorney. And what would you be counseling? Like if we had like a day one together, like, all right, what do we need to, now we've got this thing. What do we need to do now? Like where would you tell people to start from a legal perspective to get their house in order?
Okay, well, the first person they should talk to at closing is the seller, because there should be in the purchase agreement a transition period where the seller is providing transitional assistance, consulting, training, and spend as much time with that seller as you can, ideally before closing, but also after closing, so that there is a smooth transition. Because most sales tend to be asset sales. You're doing payroll from a new company. You're talking about onboarding employees. And I think the biggest thing that most buyers don't realize is a business is only as good as its people. I don't care how great your product is. I don't care how great the marketplace is. When you've got people working for you, they make or break your company. So when you walk in there and say, I just bought the company, you work for me now, that's not going to ring well. When you start off with the seller's introduction of the buyer, are we pleased to announce the next phase in the wonderful growth of our company, and the future of our company is John Doe and Jane Doe, and they're now our new owners, and we're all going to work together to be a happy family. That is so important that you set the tone with employees right from the get-go.
Yeah, absolutely. In the past when I bought companies, after we get through that initial piece and then start what we call our first 90-day plan, as chief operating officer, I would go through and I would spend time, to your point, with each of the employees, because the employees know what's going on. The owner certainly does. They hold a whole arc, but the people who really know the day to day are with those employees. And I find that if you just sit with a really humble listening ear, people want to tell you, and they want to be heard, right? And understanding what are you going to the HR department if you have one, like what are you struggling with? What do you wish, the company did more of? How are they doing? What kind of things do we need to get done better in terms of helping employees, on board versus, what happens, when they're employees here, and what things are you worried about? I find that you get a lot of support and early support from people who, when you come in and you're just listening and asking questions, as opposed to rah, 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 here we're going to do this, we're going to do that, as opposed to just take the time and really slow down and listen. How does that reflect with you? Like, when you're coming in and, with buyers who have been really successful and buyers who have not been?
Part of it is being a good listener to your employees. A lot of what the sellers told you about their employee relationship was filtered through the seller, because you probably didn't have a lot of conversations with the employees prior to closing. Ideally, you want to at least talk to key employees and get some kind of an employment agreement together so that you don't lose your key employees on day one after closing. But if you didn't have that opportunity, get your employees involved, get them participating, let them air their grievances, because if there's grievances out there that your employees have and you sound like you care and you're going to address them, you're going to keep people happy and they'll help you make your business successful. If they're nervous about a new buyer coming in and just doing a hatchet job and cutting expenses and cutting payroll, employees don't wait to get fired. They just go look for a job. And having your employees look for work when you need them in your business in this brand new transition, that's dangerous.
When you encounter companies that are already running and that kind of thing, and you're working with clients, excuse me, what are some of the major legal gaps you encounter for the first time when you first interact with the business? Like, hey, we need your help. And it's usually one thing, but as you get in there, you find other things. What are some of the typical areas that you find?
So we start the legal due diligence process with, seller disclosures and disclosure schedules that I have to review. And one of the things that is really important is compliance issues. If your business that you're buying is out of compliance now, what do you as a buyer need to get it into compliance? Or better yet, can you encourage the seller to start making it compliant now before you buy it? A good example was I worked out a deal a couple of years ago. It was a pest control company, and they didn't have, the sellers never did any I-9s with their employees. They did W-4s. They looked at socials and thought they were fine, but they didn't do I-9 forms. That's required by law. So the buyer comes in and says, well, we need to start onboarding these employees to the company that's going to be the employer after closing. Where's your I-9? And it turns out that over 40% of the workers were undocumented. And the buyer's like, hey, I'm going to lose 40% of my employees the day after closing, or I have to take the risk of not doing my own I-9s and keeping them. It's huge. So you've got to be careful that you ask the right questions early. And if it's not meant to be, it's not meant to be. Sometimes the seller is so non-compliant in their business, it's just a spider's web that you don't want to touch.
You bring up a good point. Sometimes when you're doing due diligence, you uncover these things that are maybe deal breakers, but sometimes they're not. Sometimes it's an opportunity to develop a closer relationship between the buyer and the seller, and to say, hey, look, we're really interested in buying your company, but you've really got to make sure these folks are documented first. And then you go through that, and let's say you're going to lose 20 or 30% of them, maybe hold the deal open so that to give the seller time to readjust the business so it's in better shape. And we'll get into this when we talk about the sales side. But one of the major issues we have when clients come to us and say, "Well, I want to sell my business," is that they're doing it. You're kind of coming at when they divorced or disabled, they're sick or something like that, and they're in a rush to sell the company, and we have to give them the unfortunate news like, wait a minute, we need to get your books in order, we need to do this, we need to do that, and they've got a year to 2 years of just moving it from a business they run because it's their lifestyle and their what they do, to building it in a way that someone else can come and pick it up, right? And that all the systems and processes and all that stuff are in place. So I think you bring up a really good point in that sometimes it's not a deal killer. Sometimes it's just an adjustment period, and you shift how you get more in partnership with the company. Exactly. A lot of these companies that I'm sure that you encounter, they're not just solo owners. Sometimes they have partnerships. Sometimes it's a family business. What are a good partnership or a bad partnership can make or break a company, whether it's good or not. What have you encountered in terms of, and what do you recommend from a legal perspective on when you're forming a partnership, what things to think about and how to do it well?
Okay. So anytime two or more people go into business together, if they're not already husband and wife, it's a partnership that requires, as a bare minimum, a partnership agreement. If it's a corporation, we call it a shareholder agreement. If it's an LLC, we call it a membership agreement. But there needs to be a written agreement that addresses certain provisions to the rights and responsibilities of people. And I say this because it's not just merely designed to keep honest people honest. It's about setting expectations. Sometimes partners come into a business with the expectation that their partner is going to do all the work and they're just the money behind things. And then there's a fighting about how many hours a week you're working or not working in the business. Or there's an expectation of that you're going to inject capital that you don't really have to inject. Or more importantly, if you decide that one of you wants to sell the business, is it going to get sold? Do you only sell your half of the interest? These are all things that we put into partnership agreements. And more often than not, we're representing both partners, and sometimes 3 or 4, as joint clients. If they all sign a conflict of interest waiver, it is far more efficient and cost effective for an attorney to represent the business partners in a collaborative fashion than it is for each of 3 partners to go out and get their own lawyer. And by the time they finish fighting over the red lines, nothing gets done.
Nothing's left, and there's nothing left to fight over.
Right.
Life happens in these businesses, and sometimes you have 2 partners that are working really hard doing their part in the business, and one of them just gets sick or has to exit for a while. Are there some things that you can do to help protect the partnership in the business during those times of just when life happens and you want to keep balance in the business as well?
We try to put provisions in the partnership agreement that if somebody can't perform their job description or material duties for a certain amount of time, at least they stop drawing a salary. They might still be entitled to business profits, but the partner who is working would still be entitled to their guaranteed compensation so as to properly reward and compensate those who are working, but not those who aren't. Nobody should be drawing a large guaranteed salary if they're not able to work because of medical or other issues. It's a drag on the business, and it's not fair. Now, short-term, long-term business partners, my mentality is try to cover for your partner. That could have been me. But there needs to be reasonable limitations. Sometimes you may need to hire somebody, an employee, a non-owner employee, to do the job of the partner who is either disabled, sick, taking leave to care for family. The old expression is the show must go on and the business must go on, and no one person should be that weak link that takes down a business.
Yeah, absolutely. So let's move forward into kind of the time when the partners or the owner is thinking about selling the company. If you had your best case scenario as their attorney, when is the best time to involve you, and what would be an ideal process from a legal standpoint on, to make sure that they are set up well and to have a good exit and for, to maximize their exit?
Sure. It's about assembling the right team that helps you sell your business before you actually take it to market. And depending upon the type of business and the complexity, that could be a few months to a few years prior to your actual exit date. From a legal perspective, I'd like to be reviewing on behalf of the seller the broker's agreements, because I've seen good agreements and I've seen horrific agreements. Brokers have a right to make sure they get paid, and I'm very active in the business broker community. At the same time, I've seen some of these FINRA licensed, private equity type M&A firms that just have horribly drafted upfront compensation and monthly payments. And if we don't sell your business, we're still charging you a bundle. You got to be careful. A good business broker in the states that requires a license normally only gets paid at closing when the business sells. And that's fine. I certainly want to make sure a broker doesn't do all the work and at the last minute the seller backs out. But there should be a risk on both sides of risk and reward.
Yeah, I love that. Aside from the compensation, are there any terms and broker agreements that you've seen that you would want to warn sellers to steer clear? And then what are some positive, terms that make a good partnership between the business broker and the seller and help them to work together better?
Sure. As far as the agreements go, I look for, are they using a standard industry or association type of an agreement, which is usually fair and balanced to both sides. And then I also point out to a seller, hey, there's a provision here that if you take your business off the market during the listing period, you're going to trigger a broker commission. So are you really committed to selling? If you're just going to stick your toe in the water and if nothing happens, you're going to just fire the broker. You better be prepared to pay the success fee because they're entitled. They do a lot of work. People don't realize selling a business isn't like selling a house. You're not selling a commodity. It's a process. I mean, I don't mean any disrespect to our wonderful residential real estate salespeople,
Sure.
But in a hot market, anybody can sell a house. Selling a business is real serious work. It takes a long time, and you've got to get the right person involved that's going to be in that relationship that understands what makes your business tick.
Yeah, you bring up a good point. A good business broker will use, when they're doing evaluation, when a real estate broker does a evaluation in a house, they're usually using what's called comparables or comps, which are usually coming out of the multiple listing service. It's kind of a single stop. When you're a good broker, you're using 3 to 5 decades long historical trends of data of businesses selling like theirs and then correlating them from different angles. Financial piece of it. And then if there's real estate involved, you're doing that as well. You're trying to figure out that piece component of it. And in some businesses like ours, when we sell a company, we actually put 2 brokers, same price, but we put 2 brokers in every deal to make sure that, each one can back each other up, that there's always, one person that can work on one part and one person the other, but you essentially always have 4 eyes on the deal, backed by, the other partners that are in the company as well. And we talk about those deals on a week basis. So that's a really good point.
A lot of sellers, they have a belief that their business is worth $1 gazillion and maybe it's got value, but it's not worth as much as the seller thinks it is. And one of the biggest challenges business brokers have is setting a realistic expectation of what the seller's actually going to get for the business. Sometimes you get lucky and you list a business for sale and you get multiple competing offers above the asking price. That's great, but that doesn't always happen. And, I also counsel business brokers, don't tell a seller, I'll list your business for $1 million if you think it's going to sell for $500,000. You're wasting your time. The seller is going to say, hey, why'd you mislead me as to this asking price, even though it really came from the seller themselves.
Yeah, that's a wonderful point. Ultimately, the market decides, but, we use multiple evaluation tools. Hopefully you get with a nice range and then you find a good spot, where you can do it. But it brings me to our next topic, which is the same business can be valued a certain way and it may look the same on the outside and may get a much higher value than another company. It apparently looks the same, same years in business, same revenue, same profit, that may get a much lower one. And a lot of that is really the qualitative aspects of the business, which which is things like, have they done a really great job of separating the owner from the day-to-day business? Can the business survive without the owner? Does it have standard operating procedures really well documented? Are the employees really stable? Have they taken care of their contracts? From a legal standpoint, when you help a seller prepare for sale, what are some of the things that you look at to say, here's what we need to do to make your business look as clean as possible when it goes to market with the business broker? What are some of those areas that you like to dive in and help the owner sort out from a legal standpoint, so that it passes through due diligence from a legal standpoint as clean as can be?
So we try to do basically a buyer due diligence, except it's done by the seller on themselves before they take it to market. I say, here's a checklist of all the things your buyer is going to ask you for. Within a few items here or there, I can estimate what the buyer's going to ask for. Let's find out where our holes are. Let's plug them now. Reinvent procedures that are outdated, obsolete, or non-compliant now, so we don't have to run into disclosure issues later with the buyer. Do a legal due diligence as if you were buying your own business is the mentality I take. Same thing from a financial perspective. I ask sellers, are your books clean? 100% say yes. Well, in their mind, clean means they're free of fraud. That's not my question. Clean means, if a buyer hires an accountant to do a quality of earnings analysis, comparing the bank statements to the financial statements to the tax returns, is it going to match what you think it's going to say? A lot of businesses keep their books on a cash basis, and that's fine. But most buyers will look at it from an accrual basis just because it's more accurate.
Yeah, I really love, and I think very few sellers do this actually, that where they take the due diligence list as if they were buying their own company and put themselves through the paces as if they were going to be the buyer of the company. I just love that piece. That's a really, really smart, I really do.
Yeah. For example, a lot of sellers would like to do a stock sale because of tax purposes, even though a lot of buyers are nervous about the liabilities. But if it is going to be a stock sale because you've got non-transferable licenses or you've got client contracts that might not be assignable, is your corporate structure in order? My favorite question is, where's your bylaws? And the seller says, what are bylaws?
And did you actually have meetings and document the meetings?
Maybe in an asset sale, the bylaws aren't real important, but in a stock sale, they are.
Right.
Corporate meetings, okay, I know you had them, you just didn't document them. We can recreate minutes. That's not a big deal. But your financial house and your legal house needs to be in order if the buyer is going to proceed with the transaction.
Yeah, I mean, at best, it adds a lot of friction and slows the deal down. And as we know, time kills deals. And at worst, the worst side, people say, well, if this is not clean, what else do I not know about? Right? It just adds doubt to the buyer's mind of like, well, here are the things I've already found that are obvious. Where are the things that are missing? And so you never want psychological doubt to hit your deal. Unfortunately, sometimes sellers tank their own deals when they have a good deal, a good buyer in hand. What are some of the things that you've bumped into that are completely avoidable on the seller's behalf, that if they had just done X or Y or not done A or B, to tank their deals? Like, what are I'd love to hear some of the war stories you've heard that would be good insights for people to, of course, changing the names and that kind of thing, but that sellers should learn from now so that they don't jeopardize their own deal when they're trying to exit.
So a lot of them is client contracts, your agreements with your clients or customers, whatever you call them. Most customers don't want to get locked into a long-term contract, but does the contract have an assignability provision, or does it say the client has to consent? The minute you put that draconian language, the client has to consent to an assignment, you just made an asset sale very difficult. And now you're facing the stock sale, but now you're narrowing the field of buyers who don't want to do a stock sale. So that would be one thing, making sure your licenses are current, up to date, that they're either transferable or the buyer can get a duplicate license with ease and assistance. Classification of workers has killed a lot of deals where employees are misclassified as either exempt when they were non-exempt, or they were classified as contractors when they should have been employees. And it's difficult to undo that. And I hear the common theme is, well, if I have to put my people on payroll and pay workers' comp, I'd be out of business. Well, no, you wouldn't be out of business. You would just take less money home every month as the seller, as the owner. So get used to it. Your competitors are compliant with the law, and so should you. Now, you don't see this stuff in large transactions of 10, 20, $50 million because they have HR departments. In many small businesses that we work with, the owner is the vice president of sales, chief financial officer, and the HR director. And if they don't do it right, it doesn't go well.
Right. And even if they're doing it right, they can't do it all right all the time. Right. And so it's a lot
Yeah.
to, it's a lot for one person to handle. Can't help but to think about the estate planning side of your business. Let's just kind of switch that hat a little bit. And, how do you help business owners think about estate planning, either, at the beginning or the middle and the end, but just how do you incorporate that arc of estate planning? Because it's so important that you get that right to preserve and realize sometimes decades of hard work, and that you want to enjoy a peaceful retirement and be able to do the things you want to do. What are some things to think about that you could share with folks about the estate planning side of this?
So estate planning is really both legal and financial. We're not financial advisors or
Of course.
CPAs, so I'm not going to touch that area. But when it comes to legal, I mean, it's amazing how many small business owners don't even have a trust. I mean, that's a scary percentage of how many people either say, yeah, I meant to have a trust, never got around to it, or what to trust. I mean, the last thing you want to do is have your estate go into probate at the time of your death, or heaven forbid, you have to get a conservatorship if you become incapacitated for any reason because you didn't have the estate plan and the durable powers of attorney that are necessary to keep the wheels in motion in the event of a temporary setback. So we have to counsel our clients to do that. And, we don't hold our firm, we don't hold ourselves out as estate planning attorneys to the masses. Most of our clients that we do estate plans for are owners of businesses. And we tell people, you've got to make sure that your estate is properly titled in the name of your trust. And if it's outside trust, you trigger a probate.
And when is the right time for people to form a trust? Should they be doing it at the beginning of their ownership, or when is there a trigger, if you will, that says, okay, now is the time?
Every state has what's called a probate trigger, that if your estate exceeds a certain value, that if you have assets outside of a trust over that value, you trigger a probate. In California, currently it's $184,000. If you're below that, there's a small estates exemption that allows you to get around probate. But, almost all businesses, except the very newest startups, are worth that much money. Before you buy a house, you should be buying your house into a trust. Nobody should own a home or even a condo in their own individual name and not have it in a trust.
Yeah. And for the audience who may have never encountered a trust before, what are some of the inherent benefits of putting your home in a trust, putting your business, putting your estate in a trust? Like, give them, what are the real tangible benefits and what are the risks if they don't?
Sure. The biggest risk is that when something happens to one of the spouses or the only business owner, is without that trust, you're being dragged into a probate, which is time consuming, expensive, and extremely public. If your assets are in a trust, your successor trustee will administer your estate in accordance with your wishes without court supervision. So the big issue is avoiding probate. Estate taxes used to be a much bigger issue when the estate tax exemption was under $1 million, and a lot of real people, everyday working class people, ran the risk of paying estate taxes. Today, the exemptions are so high, and they're not likely to be repealed anytime soon, even though they're supposed to sunset. I'm confident Congress will extend most of those provisions. The average ordinary small business owner today is just not going to be anywhere near the threshold of estate taxes.
Right. Right. That's wonderful. That's a great wrapper to our entire arc that we've covered today. We've covered a lot of things. Any other things that are coming to mind that, in closing, that, you would tell your son, who's, coming up in the world, that, son, you should have definitely have done these things if you go to own a business. Here are the things that I wish I had done that my clients had done. What's kind of that parting wisdom that you would love to share?
I mean, a lot of people start businesses as sole proprietors because it's very efficient, it's cost effective, and they just don't know if they're going to make it. What they don't realize is there's liabilities accruing from day one in your business, and they will haunt you for the rest of your life if you operate as a sole proprietorship. So I tell everybody, however small your business may be, anything bigger than a lemonade stand where you're selling lemonade in the street corner, you need to be either in an LLC or a corporation for liability protection. Doesn't guarantee that you'll never get sued personally, but it does provide that layer of liability protection that I always tell people is not the primary layer, it's the backup layer. The primary layer is always good insurance. And if people tell me I'm starting a business, I can't afford a corporation, or I can't afford insurance, then I have to look them in the eye and say, you can't afford to go into business. So let's get real here. And there's certain things you just have to do to protect yourself. Why put your house at risk because you launched a business as a sole proprietorship, or worse, as a general partnership?
Sage advice. Scott, I'm so grateful for you coming on today and sharing so much. It's really fantastic that you cover the entire life cycle of law for small business owners, and that you focus on small business owners. I really appreciate that you do that. Folks, if you ever want to reach Scott Williams, of course, smallbusinesslaw.org is the way to reach him. And it's just been a real honor to have you on the show today, and I'm really appreciative for the gift you're giving our audience at Buy, Build, Sell.
Been my pleasure to be here. Great questions, Ray, and I look forward to hearing your show again.